So my presentation is on incorporating international human rights law, reform of the law on abortion and domestic abuse in Northern Ireland. Northern Ireland has recently experienced significant reform in the areas of abortion law and domestic abuse. Prior to reform, Northern Ireland was anomalous when compared with the rest of the UK and the Republic of Ireland in terms of failing to provide adequate reproductive care and protections to victims of domestic abuse. However, post-reform, the regulatory frameworks adopted in Northern Ireland have been described as providing, in many respects, the most progressive regulatory frameworks on abortion and on the definition of a domestic abuse offence. This is compared to other devolved nations, England and the Republic of Ireland. This paper aims to evaluate the role that international law played in these significant reforms. In particular, the Convention on the Elimination of All Forms of Discrimination Against Women and the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Abuse, otherwise known as the Istanbul Convention. The paper examines how international obligations created a significant point of dialogue and political impetus between the Northern Ireland devolved institutions and Westminster. Prior to reform, abortion law in Northern Ireland was regulated by sections 58 and 59 of the Offences Against the Person Act of 1861 and the Criminal Justice Act of Northern Ireland 1945, which criminalised abortion in almost all circumstances, except when the pregnant woman's life was at risk from physical or mental harm, or the risk to health was permanent or serious. Further, there was no specific offence of domestic abuse in Northern Ireland. Instead, instances of domestic abuse were regulated by sections 18, 20, 42, 43, and 47 of the Offences Against the Person Act 1861. But there were inadequacies in this framework. A recognisable psychiatric illness arising from domestic abuse could constitute bodily harm for the purposes of this Act. However, states of mind which were not supported by medical evidence of psychiatric injury were not encompassed by the Act. And this meant that many victims of domestic abuse could not seek a remedy under this Act. In terms of whether reform constituted an issue that should fall within the exclusive competence of Northern Ireland or Westminster, a tension arose between the subject matter at hand and the existence of the international obligations. Abortion and domestic abuse are characterised as policing and justice matters, which are understood as devolved subject matter. Further, abortion is a healthcare issue, which again is characterised as devolved. However, there are a number of provisions in the Northern Ireland Act which indicate that the devolved institutions do not have exclusive competence over whether to comply or not with international obligations. So there are numerous examples under the Human Rights Act concerning the European Convention on Human Rights, whereby there are a number of provisions which state that the Northern Ireland Assembly would be acting outside of its competence if it did legislate incompatibly with the European Convention on Human Rights. So Section 24 speaks about subordinate legislation in this regard, and the Human Rights Act has similar provisions which state this. In terms of international obligations, we have Schedule 2, Paragraph 3, which sets out matters that are accepted. International relations, including relations with territories outside the UK and other international organisations, but not observing and implementing international obligations, including observance and implementation of human rights obligations. Section 26 states that if the Secretary of State considers that any action proposed to be taken by a Minister or Northern Ireland Department would be incompatible with any international obligations, he may by order direct the proposed action should not be taken. And also whenever the devolved institutions are required to give effect to those international obligations, he may by order direct that action shall be taken. There is little detail on who may have responsibility for securing fundamental human rights within the devolved setting. And also there is little detail on who decides the content of those indeterminate international obligations. International law itself requires that central government ensure conformity across all of its constituent nations. Article 27 of the Vienna Convention on the Law of Treaties provides that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. So there is a tension between the devolution framework and international law, which only has the intent of securing the fundamental human rights obligations. It will be demonstrated that in relation to both reform of abortion and domestic abuse, international law played a role in provoking both central and devolved institutions to take responsibility over ensuring compliance with international obligations, where citizens would otherwise be left without provision of fundamental human rights protections. The UK ratified the Convention on the Elimination of All Forms of Discrimination Against Women in 1986. It commits to participate in the periodic review by the CEDAW Committee, an independent body which monitors state party compliance with CEDAW. The periodic review process takes place every 4 years, and the UK is obliged to respond to CEDAW and articulate steps it will take to remedy breaches of CEDAW identified in the periodic review. It is also a signatory to the optional protocol, which introduces an individual complaints mechanism and a special inquiry procedure for investigation of grave and systemic violations of human rights. The CEDAW Committee, in its concluding observations, had highlighted Northern Ireland as anomalous with the rest of the UK in terms of reproductive rights and regulation of domestic abuse for decades. In relation to Northern Ireland's abortion law, in its 1999 report, the CEDAW Committee noticed its concerns with the Abortion Act of 1967, that it did not extend to Northern Ireland. And it required the government to initiate a public consultation. It noted the fundamental constitutional changes taking place in the UK, including the devolution of power to Wales, Scotland and Northern Ireland. But it cautioned against the uneven protection of women's human rights. And noted that the obligation for implementing CEDAW rested with the UK government. It welcomed the adoption of the Human Rights Act, which incorporated the European Convention on Human Rights into UK law. However, it emphasised that the ECHR did not provide the full range of women's human rights protection as CEDAW. And similar comments were reiterated in the 2008 and 2013 concluding observation reports. The special inquiry procedure into grave violations of CEDAW in the UK, in relation specifically to the criminalisation of abortion in Northern Ireland, was initiated in 2010 and not completed and released until 8 years later in 2018. But this made it coincide with the 2019 periodic review of the UK's compliance with CEDAW. So it had a huge sort of cultural impact in the UK. Paragraph 85 of the Special Inquiry Report recommends that the state party urgently repeal sections 58 and 59 of the Offences Against the Person Act and to adopt legislation to provide for expanded grounds to legalise abortion, at least in the following cases: a threat to the pregnant woman's physical or mental health, without conditionality of long-term or permanent effects, in cases of rape and incest, and severe fetal impairment, including fatal fetal abnormality. There was also a paragraph 86, which required further reaching measures regarding provision of information, services and education. Parliamentary debates in Westminster evidenced a need to provide residents in Northern Ireland with fundamental human rights protections under both the ECHR and CEDAW. In Westminster debates on the Northern Ireland Executive Formation and Exercise of Functions Bill, it was acknowledged that deciding the content of international human rights obligations and choosing whether or not to comply with those obligations did not fall within the exclusive competence of the Northern Ireland Executive. The disparity between the degree of protection offered by the ECHR, incorporated through the HRA, and the CEDAW was also acknowledged. In conformity with international law rules on treaty interpretation, the lex specialis was prioritised over the lex generalis. That means that the treaty providing the more detailed examination of the issues at hand was prioritised over the generalist human rights treaty. Emphasis was placed on the fact that the Northern Ireland Assembly was not in operation, and it was in the absence of its operation that Westminster could intervene to ensure decriminalisation of and provision of basic abortion services under the CEDAW recommendations. And Section 6 of the Northern Ireland Executive Formation Act includes paragraph 85, a verbatim of the CEDAW recommendations. And I think it is important to note that there was a sunset clause included in the legislation, and by if the Northern Ireland Executive did not reconvene by the 21st of October 2019, the Secretary of State for Northern Ireland would go ahead and provide regulations to implement Section 9 of the Northern Ireland Executive Formation Act, which is what happened. The CEDAW recommendations provided a starting point for the reform. The explanatory memorandum to the abortion regulations 2020 highlights how the 2018 CEDAW inquiry report was the foundation for the regulations, but that further work was carried out, taking into account approaches to reproductive care across the devolved nations for formulation of the new regulations. Following decriminalisation, the Secretary of State for Northern Ireland launched a 6-week public consultation, including many different organisations and people to provide input into what the best framework would be to deliver on the legal requirements of Section 9 of the Northern Ireland Executive Formation Act. The memorandum explains how the requirements of the CEDAW report were given practical effect and how guidance was provided by the other nations in the UK and the Republic of Ireland. For example, explains that Regulation 4 allows for access to abortion services up to 24 weeks gestation in cases where the continuance of the pregnancy would involve risk of injury to the physical or mental health of the pregnant woman or girl, greater than the risk of terminating the pregnancy. And paragraph 7.12 of this explanatory memorandum states, the inclusion of this ground and gestational limit means that the provision for Northern Ireland will be consistent with the position in England and Wales under the Abortion Act. 7.8 of the explanatory memorandum states that Regulation 3 allows for termination of pregnancy of up to the 12th week of pregnancy. This is a 12-week gestational limit is also consistent with provision without conditionality in the Republic of Ireland and many other countries worldwide. In line with the recommendations of the CEDAW report, this will provide access to abortion services without any conditions up to 12 weeks gestation to allow victims of sexual crime, rape and incest to access services. It also allows access to service to comply with CEDAW for women to have access to abortion where continuing with the pregnancy is a threat to the pregnant woman's physical or mental health without conditionality of long-term or permanent effects. The explanatory memorandum highlights how the 2018 CEDAW inquiry report was the foundation for the regulations, but that further work was carried out, taking into account approaches to reproductive care across the devolved nations and the Republic of Ireland for formulation of new regulations. I am going to speak briefly as well about the Domestic Abuse and Civil Proceedings Act of Northern Ireland 2021, which introduces a specific crime of domestic abuse and has the effect of criminalising coercive and controlling behaviour as domestic abuse without the requirement of a recognisable psychiatric illness. The Istanbul Convention was negotiated by the 47 members of the Council of Europe, the organisation which introduced the European Convention on Human Rights and of which the European Court of Human Rights forms part. 34 member states of the Council of Europe have now ratified the Istanbul Convention. It has not yet been ratified by the UK. In January 2019, a draft domestic abuse bill was produced by the UK government. A key purpose of the bill was to ratify the Istanbul Convention for England and Wales. And there are sort of two key articles of the Istanbul Convention which were to be incorporated into the UK. Article 33 on psychological violence, which was to ensure that coercive behaviour, coercive and controlling behaviour would be criminalised. Article 44 is about the extraterritorial jurisdiction. So the UK being willing to exercise extraterritorial jurisdiction of particular instances of domestic abuse. The bill was to be extended to England and Wales and not Scotland or Northern Ireland. However, the Pre-Legislative Scrutiny Committee of the Domestic Abuse bill stated that it was concerned about the fact that there were a number of concerns in relation to the way Northern Ireland regulated domestic abuse, including that there was no specific offence to capture coercive and controlling behaviour. It continued, and I'm quoting here, that ratification of the Istanbul Convention, which is one of the government's aims in introducing this bill, requires compliance with its measures throughout the territories of the UK. Article 34 of the Istanbul Convention requires controlling or coercive behaviour to be an offence under domestic abuse legislation. We consider it unacceptable that the people of Northern Ireland are denied the same level of protection in relation to domestic abuse as those elsewhere because of the lack of a Northern Ireland Executive and Assembly. We understand and respect the devolution settlement, but in the absence of an executive, we recommend that the provisions of the draft bill be extended to Northern Ireland. The government responded initially by including a number of Northern Ireland measures in the bill, in the absence of a Northern Ireland Executive. However, following the restoration of the Northern Ireland Executive in January 2020 and consultation with the new Minister of Justice, who was Naomi Long at that time, the measures were removed from the bill and taken forward in a Northern Ireland Assembly bill, which resulted in the Domestic Abuse and Civil Proceedings Act. So there are in terms of this new legislation, it has the effect of criminalising coercive and controlling behaviour. And Rona McQuigg's work on critiquing this domestic abuse and civil, on this new crime of domestic abuse, sets out a number of ways in which she sees that the Northern Ireland legislation has cherry-picked from across both the UK and the Republic of Ireland to come up with some of the best definitions and most detailed definitions of a domestic abuse offence. For example, exclusively including economic abuse as part of a domestic abuse offence, and providing broader definitions of the personal connection required to actually constitute domestic abuse, and other instances. And again, Rona McQuigg, I draw heavily on her work in relation to showing that progressive regulatory framework. But we can see that the international obligations under the Istanbul Convention played a major part in the political instigation of these reforms in Northern Ireland. And then there was a pursuit of best practice, looking at those obligations and also practices across the devolved nations and the Republic of Ireland. So we can see certain similarities and divergences between the experience of abortion law reform and reform of domestic abuse regulation in Northern Ireland. Yes, to conclude, the approach reflects a clear desire to conform with international standards in the field of women's rights and a sense of responsibility to conform, rather than to evade responsibility by relying on competing conceptions of competence within the devolution arrangement. Thank you.
Okay, well, good morning, everyone. And thank you very much to Jane, Connor and Adam for organising this fantastic set of events. So what I want to do this morning is explore devolution and international law through the prism of prisoner voting in the Welsh context. Now, prisoner voting has obviously been a hugely controversial human rights issue in the UK, but up until very recently, it was really an issue and a debate exclusively for UK level institutions. That, of course, has now changed. The Scottish Parliament and the Senedd have acquired legislative competence for devolved and local electoral arrangements in their respective countries. And focusing on Wales today, what I want to argue is that even though Welsh devolved institutions have acquired formal legislative competence for prisoner voting rights as they relate to Welsh elections, the complex nature of devolution in Wales, the jagged edge, that messy boundary between what is and isn't devolved within the single England and Wales legal jurisdiction, means that their ability to fulfil their human rights obligations around this issue really remains contingent on the consent and the cooperation of the UK government. My colleagues, Dr. Robert Jones and Professor Richard Wynne-Jones, in a forthcoming book on the Welsh criminal justice system, describe the Welsh government's position within that system as one of responsibility without power. And I think that encapsulates perfectly the Welsh government's dilemmas in this context. So most of this will be tediously familiar to most of you, I'm sure. So in the Hurst ruling back in 2005, the European Court of Human Rights ruled that the UK's prohibition on convicted prisoners voting in elections during the course of their sentences violated the right to free and fair elections under Article 3 of the First Protocol of the European Convention on Human Rights. And the court took particular issue with the arbitrary and indiscriminate nature of the ban, the way that it seemed to disenfranchise irrespective of the seriousness of the offence and sentence length. Now, the UK government managed to drag its feet for well over a decade, but then in 2017, the UK Conservative government, via Secretary of State for Justice, David Lidington, announced a set of administrative changes. The Lidington Compromise, as Colin Murray has called it, really had two key elements. First of all, the warrant of committal would be amended in England and Wales. So prisoners at the point of sentencing or close to the point of sentencing would be informed that they would lose the right to vote, addressing what was arguably a very minor point in the original Hurst judgment. And secondly, prisoners released on temporary licence would be enfranchised. By the UK government's own estimations, this would apply to up to 100 prisoners on any given day. Now, despite the fact that these administrative changes left the legislative ban in place, in December 2018, the Committee of Ministers of the Council of Europe accepted those measures as resolution of the Hurst proceedings and closed the matter. But just as things were wrapping up at the international level, things get more complicated. Prisoner voting becomes a devolved issue. And because devolved institutions have a legal obligation to respect the convention rights, discussions begin in earnest in both Scotland and Wales about what they might need to do about prisoner voting. In Scotland, this culminates with the Scottish Elections Act, which enfranchises prisoners serving up to 12 months in prison. In Wales, it culminates in the Welsh Government's plans to enfranchise prisoners serving under 4-year sentences, but crucially, those plans are still yet to be implemented for reasons which I'll go on to explore. Now, despite the fact that the Welsh Government hasn't been able to legislate, there remains a very, very compelling case for it to proceed with legislation and to enfranchise at least some prisoners for a variety of reasons, and several of which relate to the Lidington Compromise. So first of all, as I said, the legislative ban, the original source of the violation in the Hurst ruling, remains in place. But secondly, the solution of enfranchising temporary licensed prisoners arguably exacerbates or adds another layer of arbitrariness to the current system. So in practice, whether prisoners will be able to vote will depend on their release date or the timing of the election, whether they were registered at the point of sentencing, and whether they remain on the electoral register, and also on the type of temporary license which they have. So whether they're released into the community for a day, for example, or whether they're released for longer periods, all of which will afford differential voting opportunities. And I think it's also important to remember that disenfranchisement is arguably most acute in the Welsh context, because it's been consistently demonstrated that Wales records the highest rate of imprisonment in both the UK and Western Europe. Now, the case for Senedd legislation becomes stronger when we consider the empirical evidence on voting by eligible prisoners in the UK. So it's important to remember that remand prisoners, among others, are eligible to vote in the UK, and that on any given day they number in their thousands. So with Dr. Robert Jones, I've recently conducted a survey with the Association of Electoral Administrators to try and find out a little bit more about their experiences with prisoners who are eligible to vote. And we found fairly scant evidence of uptake by eligible prisoners. So we had 133 responses from generally very experienced administrators, people with at least 6 years experience, and only about a quarter of them have said that they've ever received an application from a prisoner. And of those that do have experience with prisoners, overwhelmingly they've said they've only received between 1 and 5 applications. So very scant uptake from this picture. But the survey data also highlights a number of systemic obstacles faced by eligible prisoners in the UK. So there seems to be a lack of support within prisons. Administrators regularly receive applications which are incomplete or not completed correctly. Certainly in England and Wales, there is almost non-existent communication between electoral administrators and the prison service. Administrators are often unable to establish the information that they need about the prisoners that they're dealing with in order to process applications. And then there's the problem of frequent prisoner relocation. So during the course of their sentences, prisoners are often moved throughout the prison estate, which often results in electoral correspondence being disrupted, postal votes going astray, and so on. And a report of a Senedd committee in 2019 also identified that there was a lack of knowledge among eligible prisoners that they were eligible to vote, despite the Lidington Compromise. So when we take all of that together, it seems as though the scale of disenfranchisement in the UK may actually be even more severe than we thought previously. So there's a compelling case to act, but the Welsh Government faces a number of obstacles. First of all, it faces the supermajority requirement. So as is the case in Scotland, if there are to be changes to devolved electoral arrangements in Wales, they require the support of 2/3 of the majority in the Senedd. And this has already played a significant role in the prisoner voting debate in Wales. So the Welsh Government last year included provisions in the Local Government and Elections Wales Bill on prisoner voting. But around the start of the pandemic, it's the coalition of support that it was relying on to get these passed seemed to break down, or at least appear a little bit more uncertain. And the Welsh Government was forced to remove those clauses. And so, as Colin Murray says, the supermajority requirements were having a telling effect. The Welsh Government was not confident it could meet the 40 votes that would be required. And interestingly, since those plans were shelved, there have been no further developments around this issue. And commitments on prisoner voting are notable by their absence from the Welsh Labour 2021 manifesto. But arguably the much more serious obstacle for the Welsh Government is the jagged edge within the criminal justice system in Wales. So on the one hand, Westminster retains control for core aspects of criminal justice, the criminal law and sentencing, the courts, the prison estate, and so on, whereas the Senedd has control for most of those policy areas upon which any effective criminal justice policy will really depend: health, education, housing, and so on. And then piled on top of this, we have this split responsibility for prisoner voting rights. And so what we have in Wales is what Rob Jones and Richard Wyn-Jones call a policy space of intersecting competencies and responsibilities shared between two governments with different political priorities and accountable through different electoral mandates. And adding to the complexity is the distribution of the prison population within the single legal jurisdiction. So Welsh prisoners, a third of Welsh prisoners are held in England, scattered across more than 100 English prisons, whereas English prisoners make up a quarter of the prison population in England, which really profoundly complicates what the Welsh Government can do in this context. Now, in order to illustrate the complexity of these arrangements, I just want to consider 3 different reforms which the Welsh Government could potentially consider. The first is disenfranchisement based on sentence length. As we've seen, this is the Welsh Government's preferred option. It wants to extend the right to vote to prisoners serving under 4 years who are across the England and Wales prison estate. But the problem with this system is it effectively ties the Welsh electoral franchise and the scale of enfranchisement or disenfranchisement to UK government sentencing policy. And we can see how that's unfolding already. So the UK government is committed to increasing the use of longer term sentences. And as it does so, under Welsh government plans, the corresponding proportion of Welsh prisoners who would be entitled to vote would diminish. So in a sense, the threshold, the rationale for disenfranchisement would be outsourced to Westminster. But more problematically still, this proposal would require the UK government's cooperation, including potentially facilitation of prisoner voting across up to 100 English prisons. Given the UK government's steadfast opposition to enfranchising prisoners, that cooperation seems unlikely at this point. But a further problem is that this proposal would create differentiated rights within prisons. So in HMP Berwyn in North Wales, for example, you could have two prisoners, one from Wales, one from England. They're both serving similar sentences for the same criminal offences. They're both within the same legal jurisdiction. Both are in receipt of devolved services such as health, but only one of them is able to vote. An alternative option would be for the Welsh government to enfranchise those prisoners who are held in Welsh prisoners. It might want to do so on the basis that those prisoners are in receipt of devolved services, and so the Welsh government should be accountable for how it delivers those services. But this runs into just as many difficulties. So again, it would require UK government facilitation, and this time that facilitation would perhaps be even more unlikely because it would effectively enfranchise a significant section of the English prison population, thereby undermining UK government policy on English prisoners. But then it also exacerbates the fear of prisoner voting blocks, so kind of high concentration of voting prisoners, which could potentially sway the results of particular constituencies, which has been a big concern for some politicians. But even if that cooperation was forthcoming, this solution would effectively disenfranchise more than a third of Welsh prisoners who are held in England, including all of Welsh women who are currently incarcerated exclusively in England. A third and final option, although it's not really an option, would be a judicial discretion to disenfranchise, so allow judges to take away voting rights on a case-by-case basis, so tailoring disenfranchisement to the facts of the particular case and hopefully allowing disenfranchisement to become a more proportionate measure. And the case law of the European Court of Human Rights suggests that this is potentially one way of securing compliance with the European Convention. But it's simply not an option for the Welsh government because sentencing is reserved, and under current political circumstances, it's absolutely inconceivable that the UK government would grant the competence to Welsh institutions for sentencing. So to tie this together, clearly there are big questions around whether Welsh electoral law is compatible with the European Convention on Human Rights as it stands. But the Welsh government and the Senedd are stuck between a rock and a hard place. The devolved powers in this area are partial and they are contingent. They are contingent upon a Senedd supermajority and they are contingent upon the acquiescence of the UK government. So viewed in the round, I think we can say that Article 3, Protocol 1 rights of Welsh prisoners remain very much a shared responsibility of Welsh and UK governments. Or viewed differently, there's essentially a codependency between them. Both relies on the other to cooperate with the other and take positive steps to ensure that these rights are respected. I'll leave it there. Thank you.
Great, thank you very much, Greg. Thanks. So our final main speaker, let's head now to Edinburgh, where we will hear from Kasey McCall-Smith. Thanks, Kasey.
Great. So I'll just crack on. I don't PowerPoint very well. So I'm going to talk about incorporation of the UN Convention on the Rights of the Child in Scotland, the UNCRC bill. But first, my thanks to Jane, Connor, and Adam for organizing and for inviting me to be here. As I'm sure most of you know, we've had a lot of activity regarding incorporation here, and the UNCRC bill is particularly interesting in the context of this workshop because of the questions that arise as a result of the incorporation bill, which is kind of a scent test for future incorporation legislation that is being contemplated. So, as a devolved nation within the UK, Scotland has taken an increasingly leading role in entrenching children's rights. Though the UK ratified the UN Convention on the Rights of the Child in 1991, it has done very little to implement these rights consistently into national law and policy frameworks. Children's rights protections in the UK have been entrenched predominantly through the efforts of the devolved nations, including Scotland. As a result of the successive updates to its devolution settlement, Scotland is able to legislate and develop children's rights laws through its policies distinct from the UK, which is the actual state party to the convention. Children's rights have been a focus of the Scottish National Party's governance platform for several years and have long featured in Scottish politics. In April 2019, the First Minister pledged to incorporate children's rights and to do this through through a piece of legislation. So it was from this, we use this as a kind of jumping off point, I think, because there was a firm commitment. And so here, what I'm going to do is consider how Scotland has navigated its devolved competences to implement children's rights obligations under the UNCRC. First, I'm going to offer a brief overview of the legal settlement between the Scottish and UK governments as it pertains to this particular issue and the growing attention on children's rights in kind of post-devolution Scotland. Then I'm going to talk about some of the key features of the UN Convention on the Rights of the Child Incorporation Scotland Bill, or Incorporation Bill as I'll call it, and expand on how further entrenchment of the UNCRC in Scotland through full and direct incorporation has triggered a bit of a power struggle between the UK and Scottish governments, leading to a judicial review of different aspects of the incorporation bill. And then finally, we're going to look at, or I'm going to introduce a few aspects relating to a child's right to participation in order to illustrate how different issues have been addressed by the UK government and the Scottish legal system to the detriment of children's rights, thereby reinforcing the importance of maintaining the key enforcement aspects of the incorporation bill, which is a major focus of the UK government's judicial review. So, in many ways, to what extent can and should central governments intervene when a devolved nation fails to afford its inhabitants the rights ensured by international treaties? This was one of the questions that was set. But really here, I'm going to be talking about kind of the opposite, in that Scotland in its devolved capacity is trying to increase the entrenchment of the rights afforded by the UNCRC in kind of opposition to the UK government, which is challenging its ability to do so. So the Scotland Act of 1998 under Schedule 5 and its subsequent updates to the devolution settlement expressly permit Scotland to implement international obligations. As a result of the successive expansions to the devolution settlement, the Scottish Parliament may legislate in relation to a wide range of issues, including education and training, health and social services, housing, law and order, some aspects of equality, social security, and taxation. So the ability to respond to a broad range of law and policy areas underpins the opportunity to further entrench the UNCRC rights into Scots law, as the UNCRC includes civil, political, economic, social, and cultural rights. The Scotland Act also outlines that any act of Scottish Parliament will be unlawful if it runs counter to the European Convention on Human Rights. Therefore, this adds an additional layer of human rights protection that applies to all individuals. However, the ECHR does not directly address the special needs of children, nor does the Human Rights Act of 1998 that incorporated it into UK law. So while Scotland has already set a course for strengthening children's rights prior to devolution, individually and collectively, the further powers that have been devolved to Scotland over the past 2 decades have really made the potential to make rights real important and obtainable here in Scotland. So in short, kind of the legal demarcation between the devolved and reserved powers, even when the line is blurry, enables Scotland to pursue improving children's rights in very distinctive ways. So the incorporation bill adopted by the Scottish Parliament on the 16th of March of this year offers the first real opportunity to entrench the kind of dynamism of the UNCRC in law. The bill signals a massive forward step by Scotland to deliver on UNCRC Article 4, which requires states to undertake all appropriate legislative, administrative, and other measures for implementation of the UNCRC. So that very common human rights obligation that we find in all of the international treaties. Once the bill takes effect, I'm being very proactive about this and not thinking that this won't happen, Scotland will become the leader among the devolved nations of the UK in terms of securing children's rights, and also provide a strong signal to the rest of the world about its commitment to promote and protect children's rights. The bill takes a maximalist approach by directly incorporating the UNCRC, both by reference and through direct transposition of the convention into legislation. Not only does it directly transpose the bulk of the UNCRC articles, there are a few minor ones that have been accepted because of the devolution arrangements. It further includes the 2 optional protocols of the convention and keeps open the possibility to add additional articles of the convention and protocols in the event of further devolution or UK ratification of the 3rd optional protocol on an individual communications procedure. So that's under Section 5 of the bill. Specifically thinking about the extent to which the devolved nations have the competence to decide upon the content of indeterminate international legal obligations within their own nation, it's important to note that Section 4 of the Incorporation Bill offers the interpretation toolkit. So when questions arise in relation to the UNCRC requirements, it includes the entirety of the UNCRC plus its optional protocols as set out in the schedule to the bill. It includes the preamble. So these very much reflect the Vienna Convention on the Law of Treaties interpretation rules. But in addition, the incorporation bill goes a step further in order to recognize the evolutionary approach to human rights law and includes general comments, concluding observations, any observations or decisions taken under the 3rd optional protocol, as well as recommendations that come from the days of discussion, which is unique to the UNCRC as well as the CRPD. So on the 24th of March, so the following week, basically, after the bill was unanimously adopted by the Scottish Parliament, the Secretary of State for Scotland notified the Deputy First Minister that the UK intended to use its Section 33 power under the Scotland Act to refer questions of legislative competence regarding several issues of the bill to the UK Supreme Court. This is only the 2nd time that has happened, so it was quite a big move, particularly in light of the extensive discussions that had been had prior to the adoption of the bill, particularly during stage 3 of the legislative process here in Scotland. So now I'm going to talk about a few of the key features of the bill that relate directly to the UK challenge. So the incorporation bill includes a more comprehensive range of duties with which the different parts of the Scottish Government will be required to comply. Firstly, Section 6 of the Incorporation Bill requires all public authorities, including Scottish ministers, courts, local authorities, health authorities, children's hearing panels, and other authorities listed under Section 16 to act compatibly with the UNCRC. Throughout the bill, the language makes clear that the scope is focused on the Scottish ministers and public authorities administering Scots law obligations. And this was an extensive part of the discussion in the lead up to the original draft of the bill, with many consultations regarding the devolved competence of the Scottish Parliament on these issues. The UK government has concerns with Section 6 in relating to the legal obligations, as it could be seen to place UK government ministers, obligations on UK government ministers in reserved areas. So this in turn means that the effect of the legislation may not be clear to citizens, or at least this is what the UK government is concerned about, ostensibly. And they are concerned that citizens might think that the UK government might have to be accountable in terms of the UNCRC obligations, as opposed to merely those organs of the Scottish government that are outlined in the bill. Secondly, Section 11 requires Scottish ministers to develop, publish, and review a children's rights scheme, detailing the arrangements that they are putting into place to ensure that they comply with their Section 6 duties. The bill subsumes the Children and Young Persons 2014 duty on Scottish public authorities to publish reports on how they are ensuring compliance with the UNCRC. The change of language here is important because it went from respecting children's rights with the Children and Young Persons Act to ensuring. And so that's quite significant in terms of legislative language because it's intended to guarantee greater attention to implementation than ever before. So in light of the variable, devolved, and reserved competences, a great deal of work, as I said, was done prior to the introduction of the bill to ascertain how Scotland's obligations would fit in with the reserved aspects of implementation, though only time, as with all legislation, will actually reveal some of the potential sticking points, but this is true for any piece of legislation. Enforcement of the UNCRC rights is potentially the most impactful aspect of the incorporation bill. And this was what was truly a hard-won fight for the decades that civil society has been, that incorporation has been part of their platform. So the enforcement mechanism. Under Section 7, a public authority's failure to act on its duty or to act, if it acts incompatibly with the UNCRC, this will give rise to a legal claim. So this was really the coup de grace for the incorporation bill. This feature of the bill addresses many of the existing gaps in Scots law by enabling UNCRC rights holders, so all under 18s, to directly raise the Articles of the Convention in any legal proceeding. So as passed, not only would the Scottish courts have an obligation to determine breaches of the UNCRC, under Section 20, they would be able to make a strike-down declarator against Scottish laws predating the legislation. And here I note Scottish laws predating the legislation coming into force. So this would aid in rectifying existing laws that directly or indirectly run contrary to the UNCRC. Additionally, Section 21 enables courts to deliver a declarator of incompatibility for proposed legislation reflecting the Human Rights Act's approach to the ECHR, and that would also protect children's rights before a conflicting law would be adopted. Prior to the incorporation bill, Scottish courts had no obligation to give effect to the UNCRC in any proceedings. They could use it as an interpretive tool, but that was the limit. The UNCRC, thus the UNCRC in legalizing the justiciability of children's rights offers the strongest option in terms of enforcement and is definitely the crowning achievement of the bill. So it's these elements, the enforcement, so Articles 19 through 23, or Sections 19 through 23 of the Incorporation Bill, and the Section 6 obligations on public authorities and ministers that the UK is challenging. So as of yet, the final decision of the UK Supreme Court has not been delivered. And so what's going to happen, we don't know, despite, I mean, these issues speak directly to the understanding of how the UK and the Scottish governments interpret issues of devolved competence for different children's rights. But it's important to clarify that as Scotland moves forward with further human rights incorporation, this is going to be quite a crucial decision by the Supreme Court, and it will play a key role in how future legislation incorporating CEDAW, the CRPD, and the CERD is adopted, and including the ISESCR. So I just want to quickly illustrate, I think I've got about 5 minutes left. Is that right, Roger? 5 minutes? Okay. So I just wanted to illustrate the potential in terms of the enforcement, in terms of children's rights, and just use one example of how the distinction between the UK legislative framework and interpretation options have worked between the Scottish and UK levels of government. And I'm going to use the right to participation. So I think this is a good case because it demonstrates how there hasn't been particular engagement with the UNCRC, even at the UK Supreme Court level, when we have important issues regarding children's rights. So UNCRC Article 12 is the kind of international codification of a child's right to be heard, and is recognized not only as an independent right, but also as one of the 4 general principles that should be used to interpret all of the articles of the UNCRC. It's notable too that Article 5 of the UNCRC recognizes the evolving capacity of children. So this both tempers and strengthens children's ability to engage their various UNCRC rights in line with each child's personal development. So the evolving capacity for autonomy is a distinctive characteristic of the rights outlined in the UNCRC, and participation rights build on this capacity. So therefore, it's appropriate to think of the evolved interpretation of Article 12, the Article 12 right to be heard in concert with Article 5 as a right to participation for children, as it reinforces that they should have the opportunity to express their opinions and be part of decision-making processes in all matters that affect them in line with their evolving capacity. So though participation is not expressly used in the UNCRC, facilitation of the right to be heard is now broadly conceptualized across children's rights literature as a right to participation, and it's derived from the combined reading of Articles 12 and 5 of the UNCRC. So a child's participation in decision-making in relation to their personal lives can be succinctly described as the individual dimension of participation. The individual exercise of participation rights squarely engages with Eva Brem's construction of children's rights as emancipation rights. And this is particularly important as children attempt to engage all of their UNCRC rights, such as the freedom of expression. Brems notes that a crucial feature that these and other emancipation rights have in common is that the sustainable realization of these rights does not only or even predominantly take place in the vertical relation between children and the state, but that they present some of their main challenges in the horizontal relations among individuals in society. This is something that anyone who's dealt with children's rights will clearly recognize, as in, is it pitting children against their parents or children against their teachers? But it's about reinforcing that there has to be a better understanding of how children's rights sit in the context of other human rights. So educating society about how children activate their rights supports children to move away from their historic characterization as property or purely vulnerable beings in need of protection. This transition from being viewed as objects of the law to subjects of the law that are capable of autonomous active engagement with other members of society, as well as the state and its functions, is crucial to reinforcing participation rights. So I'm going to look at how children's participation rights are used in the children's hearing system, which is a unique Scottish feature that supports children that are engaged with the legal and justice system. So the UNCRC demands that states transform the decision-making process and make it more inclusive by bringing views into play that would otherwise go unheard. This is essential to recognizing children as evolving dynamic citizens, which historically has been contested. So transforming their role in contemporary society demands that citizenship not be viewed simply as status, but as the culmination of the practices of making citizens, so the social, political, cultural, and symbolic practices. Children face many forms of oppression in their path to citizenship, and this oppression is reflected in the broad range of social, political, and cultural and symbolic barriers that have historically driven an ageist binary and binary construction of personhood. So an individual is either a child or they're an adult. So in this binary, children are excluded from engaging in all manner of decision-making processes. In Scotland, as in other jurisdictions, the ability of children to participate in decision-making has been that affects their lives has been restricted by the presumption of the Magic 12. And I'm just going to take 2 more minutes because I realize I'm close to the end of time. And so in law and policy, it's often been that if a child wasn't the age of 12, then they were automatically not considered to participate. Now, there have been some evolutions and creative methods for engaging children, particularly in family law mechanisms, but those haven't always been successful, and it's definitely not been consistently observed how the state has engaged with children or encouraged children to engage with processes. The Children's Scotland Act of 1995 is a key feature of Scots family law and defines the legal rights between children and young people and their parents or guardians. More than any other area of law, this is an important because family law regulates our most intimate relationships. So we need to consider how existing Scots law prior to the incorporation bill measures up against the UNCRC. So the Children's Scotland Act centers on the welfare of the child and is concerned with supporting children and their families as they go through the children's hearing system. However, it places a limitation that children's views are only taken into account so far as practicable, and this is reflected widely in Scots policy. However, in recent cases, there has been a very clear avoidance of even practical implementation of a child's right to access. So there have been some updates to this law, but these come on the back of the case that I'm going to present. So under the children's hearing system in Scotland, siblings are not included as relevant persons necessary when a compulsory supervision order is being made or considered. A relevant person is a necessary category of legal persons required to attend children's hearings and is designed to it's typically limited to parents, guardians, or carers. So this gap means that siblings that are related to a child, if they are between the age of 16 and 18 or over 18, they have no say. And so this could mean that their ability to maintain contact with their siblings when they've all been removed from their parents is not preserved. So this has obviously a massive impact on children. So there were challenges raised in 2 cases before the Supreme Court, and these hinged on whether a child could be heard. The ABC case and the XY case, I can give the full sites later, but basically from an adult perspective, they didn't view siblings as being relevant, particularly those that had aged out of the children's care system, so children that were over age 16. So a brother tried to challenge his younger siblings' compulsory supervision order so that they ensured that his contact with his brother was maintained. The Supreme Court looked at this existing Scots law and left it ultimately to the Scottish policy. They said, well, there is guidance at the administrative level that will enable the court, or will enable the children's hearing system to consider this. But basically, they didn't make it about the child's right. They made it about what happened in an administrative proceeding and rules that could be changed every year. So ultimately, the child's right was not engaged in any way, and it was left up to public officials and whether it was convenient for them to consider the child's view or to engage the child in this process. And so just to conclude, I think this case is really effective in demonstrating how this distinction of the approach taken by the British government and the approach that the incorporation bill will put forward, in that 16-year-old wouldn't slip through the gaps and his voice would be heard in the context of maintaining sibling contact. And that just reinforces one of the key reasons why the enforcement provisions of the UNCRC incorporation bill are so essential in terms of actually making a difference in children's rights and their ability to engage in the normal functions of the citizenry. Thank you.